Respected learned brothers and sisters, this is Advocate Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a topic from criminal law, and it is very interesting, and it is murder or culpable homicide not amounting to murder. Bharatiya Nyaya Sanhita 2023, Section 100 deals with culpable homicide and Section 101 deals with murder. Previously, in Indian Penal Code, Section 299 for culpable homicide and Section 300 for murder. Now, punishment for culpable homicide not amounting to murder, that is Bharatiya Nyaya Sanhita Section 105 Part 1 and 2, and punishment for murder Bharatiya Nyaya Sanhita Section 103 subsection 1. So I will not touch circumstantial evidence in this topic because I have already prepared a video separately, and I also not touch dying declaration because it requires full-fledged video. It's a very deep subject. Now, Bharatiya Nyaya Sanhita punishing section is Section 103, subsection 1. Now, subsection 1 reads like this: whoever commits murder shall be punished with death, imprisonment for life, death or imprisonment for life, and shall also be liable to fine. Prosecution must establish homicidal death as a primary fact. Homicidal death is a primary fact. For the purpose of proving the charge of the offence under Section 302 IPC and as per BNS 103 subsection 1, the prosecution must establish homicidal death as a primary fact. In order to convict an accused under Section 103 subsection 1 of BNS, the court is required to first see as to whether the prosecution has proved the factum of homicidal death, whether there is homicidal death or not. Thus, what is the relevant factor to ascertain murder? The basic constituent of an offence under Section 103 subsection 1 of BNS is homicidal death. This is the primary fact. If an act falls under any one of four clauses of Section 101, to bring it out of its purview, it must be proved that it falls under any one of five exceptions. There are exceptions. The right approach in cases of culpable homicide is to first find out whether the offence falls under any of the four clauses, that is, clauses firstly to fourthly, under Section 101 of BNS. If it is found, then the court has to see whether the case is covered by any one of the five exceptions to Section BNS 101, which would make a culpable homicide not amounting to murder. Straightaway, no one can charge for murder. The offence, if proved to fall under one of the said exceptions, would be punishable under Section BNS Section 105, if it comes under exception, or otherwise it would be murder, punishable under Section 103 subsection 1. So for any defense lawyer, it is the first duty to see whether we can press into service any exceptions. Once it is found that the act falls under any one of the clauses under BNS section 101, to bring it out of its purview, it must be proved that it falls under any one of the 5 exceptions of BNS section 101. Citation is Devmorari vs. State of Madhya Pradesh, AR 2022, Supreme Court 2396. The Honorable Apex Court, while considering section 299 of IPC, this is an old section, so it is 299 in grades are same. In AR 19 Devmorari vs. State of Tamil Nadu, reported in AR 1976, Supreme Court 1519, has been pleased to hold at para number 32 and 33, which is being quoted here under as para number 32 of this citation. For this purpose, we have to go to section 299, which defines culpable homicide. This offence consists 299, new section is BNS section 100. It defines culpable homicide. And what are the ingredients? The offence consists in the doing of an act A with the intention of causing death, or B with the intention of causing such bodily injury as is likely to cause death, or C with the knowledge that the act is likely to cause death. This C is very important. Section 4, benefit. Liability of accused can make it a case of culpable homicide not amounting to murder. The sine qua non for the application of an exception to section 300 means new section 101. 101 defines murder, and 103 the punishing section. In the case of murder, but the accused claims the benefit of exception to bring it out of that section and to make it a case of culpable homicide not amounting to murder. The perusal of the provision would reveal that 4 conditions must be satisfied to bring the matter within exception 4. If you want to go for culpable homicide for less punishment, then it should fall under exception 4. And what are the ingredients? Number 1. What defense has to go? It was a sudden fight. There was no premeditation. 3. The act was done in the heat of passion. And that last, the assailant had not taken any undue advantage or acted in a cruel manner. On a plain reading of exception 4, it appears that the help of exception 4 can be invoked if death is caused A. without premeditation, B. in a sudden fight, C. without the offender being taken undue advantage or acted in a cruel or unusual manner, and D. the fight must have been with the person killed. That is important. The fight must have been with the person killed, with the disease. To bring a case within exception 4, all the ingredients mentioned in it must be proved. Para number 57, 58 and 59. Citation Balu Salam Khalde versus State of Maharashtra. Year 2023 Supreme Court 1736. Another citation is Premchand versus State of Maharashtra. Year 2023 Supreme Court 1487. Now BNS section 101, that is for murder, and punishing section 103 is 1. Now, if case falls under BNS section 100, then punishing section is 105, and it is divided into 2 parts, 1 and 2. Bharatiya Nyaya Samhita, section 105. Punishment for culpable homicide not amounting to murder. It reads as without. Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life, or imprisonment for is a description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. From life imprisonment it has come down to 5 to 10 years. If the act by which the death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death. Now this is the first part of section 105 of BNS. Now second part, this is interpretation for punishment, BNS section 105 part 2. Or with imprisonment of the description for a term which may extend to 10 years and with fine. If the act is done with the knowledge that it is likely to cause death, but without any intention, knowledge is there but intention is not there, to cause death or to cause bodily injury as is likely to cause death. So 105 is in two parts. Applicability of section 105 part 2. To make out an offence punishable under section 105 part 2 of BNS, the prosecution has to prove the death of the person in question, the duty of the prosecution, and such death was caused by the act of the accused, and that he knew that such act of his is likely to cause death. The determinative fact would be the intention to cause such injury and what was the degree of probability, grace, medium, or the lowest degree of death, which determines whether the crime is culpable homicide or murder. The injury an element of callousness to the result which denotes or signifies the intention. This is given in citation Prasad Pradhan vs. State of Chhattisgarh, year 2023, Supreme Court 643. Now the question arises, whether on the basis of factual aspects, the case will come under the purview of part 1 or part 2 of BNS section 105. How to be decided whether this falls under part 1 or part 2 of BNS section 105, that is culpable homicide not amounting to murder. The difference between the two parts of BNS section 105 is that on the first part, the crime of murder is first established and the accused is then given the benefit of one-off exception to section 101 murder. While in the section 105 part 2 of BNS, the crime of murder is never established at all. Therefore, for the purpose of holding an accused guilty of the offence punishable in the second part of BNS section 105, the accused need not bring his case within one of the exceptions under BNS section 101. Now what are the duties of the court? What court has to see? The court must necessarily have regard to the nature of weapon use. What are the considerations? The nature of weapon use, the ferocity of attack, part of the body injured, multiplicity of injuries, degree of force used in causing injury, extent of injury, the manner of attack, the circumstances preceding and attendant on the attack, and all other surrounding circumstances. The fact that the act is done without premeditation in a sudden fight or quarrel. Assault was not premeditated and intentional. It was done in a sudden heat of passion and spur of moment. These are the factors to be considered if it is there. Or that the circumstances just like that the injury was accidental or unintentional, or that he only intended a simple injury will lead to the inference of guilty knowledge, and the offence would be one under Part 2 of BNS Section 105. Now, very famous citation I am quoting, in Virsa Singh versus State of Punjab, year 1958 SC 465, has laid down guiding principles that the prosecution must prove. Number one, there are three. Number one, that the body injury is present. There should be presence of injury on the body of the disease. Number two, that the injury is sufficient in the ordinary course of nature to cause death. Number three, that the accused intended to inflict that particular injury, that is to say it was not accidental or unintentional, or that some other kind of injury was intended. From the genesis and manner of offence, it can be well inferred without any doubt that there was no intention on the part of the appellant, accused, to kill the disease, and also there is no intention of the appellant, accused, to inflict that particular injury on the person of disease. This should be the defense of the accused. Even accepting, this is another defense, even accepting the case of the prosecution to be true, even then, at least this case would fall under Part 1 or Part 2 of Section 105 of BNS, that is Bharatiya Nyaya Samhita 2023, taking into consideration the fact that in the manner and mode in which the murder is alleged to be committed, no case under Section 103 subsection 1 of BNS is bear out. It is a strong defense. Now, distinction between intention and knowledge. The intention and knowledge of the accused are subjective and invisible states of mind, and the resistance has to be gathered from the circumstances such as the weapon use, just now I said, the ferocity of attack, multiplicity of the injuries, and all other surrounding circumstances. Knowledge is a bare awareness and not the something as intention that such consequences should ensue. As compared to knowledge, intention requires something more than the more foresight of the consequences, namely the purposeful doing of a thing to achieve particular end. Intention has to be there. The first part of BNS Section 105 will apply when there is guilty intention, whereas the second part of this section, Section 105, will apply when there is no such intention, but there is guilty knowledge. This is the difference between these two. Now I am quoting a very good citation, 2024, that is, Criminal Law Journal 2566, Jharkhand High Court. Bamaya Pinju versus State of Jharkhand, para number 36, page number 2575. In the case of State of Andhra Pradesh versus Raya Varapu, Puninga, 1976, 4 Supreme Court cases 382, equivalent AR 1977 SC 45. The Honorable Apex Court, while clarifying the distinction between Section 299, that is BNS Section 100, and Section 300 of Indian Penal Code, that is Section 101 of BNS, and their consequences held as under 12. In the scheme of the Penal Code, culpable homicide is genus and murder is species. All murder is culpable homicide, but not vice versa. Speaking generally, culpable homicide not amounting to murder for the purpose of fixing punishment proportionate to the gravity of the generic offence is to be considered. The court practically recognizes 3 degrees of culpable homicide. This is very important. This is to be remembered. by all the different scholars. There are three degrees of culpable homicide. The first is what may be called culpable homicide of the first degree. This is the greatest form of culpable homicide, which is defined in section 300 as murder and equivalent is BNS section 101. The secondary term as culpable homicide of the second degree. This is punishable under the first part of section 304, that is BNS section 105. Then there is culpable homicide of the third degree. There are three divisions. This is the lowest type of culpable homicide. The case has to be brought in this. And the punishment provided for it is also the lowest among the punishment provided for three grades. Culpable homicide of this degree is punishable under the second part of BNS section 105. These are the very important points. Now the case laid down in 1958 SC 465 with Singh versus State of Punjab. For the applicability of clause thirdly is now ingrained in our legal system and has become part of the rule of law that are laid down guiding principles. We can say local classicus. It is clearly laid down that the prosecution must prove, number one, that the injury is present on the body. Number two, that the injury is sufficient in the ordinary course of nature to cause death. Number three, this is very important for defense. The accused intended to inflict that particular injury, that is to say, it was not accidental or unintentional, or that some other kind of injury was intended. In other words, clause thirdly consists of two parts. The first part is that there is an intention to inflict the injury that is found to be present, and the second part that the same injury is sufficient to cause death in the ordinary course of nature. Under the first part of the prosecution has to prove from the given fact and circumstances that the intention of the accused was to cause that particular injury. Whereas under the second part, whether it was sufficient to cause death is an objective inquiry and is a matter of inference or deduction from the particulars of the injury. The language of clause thirdly of section 300, new BNS section 101, speaks of intention at two places, and each of the sequence is to be established by the prosecution before the case can fall in that clause. The intention and knowledge of the accused are subjective and invisible states of mind, and the resistance has to be gathered from the circumstances or given a lot of circumstances, such as the weapon used, the parasitic attack, multiplicity of injuries, and other surrounding circumstances. The framers of the code designedly use the word intention and knowledge, and it is accepted that the knowledge of the consequences which may result in doing an act is not something as the intention that such consequences should ensue. Firstly, when an act is done by a person, it is presumed that he must have been aware that certain specified harmful consequences would or could follow. But in the knowledge is bare awareness and not the same thing as intention that such consequences should ensue. As compared to knowledge, intention requires something more than the mere foresight of consequence, namely the purposeful doing of a thing to achieve a particular end. Now this in citation to 2024, Sierra 2.66, Jharkhand, I already referred it. Para number 5, page number 2576. Section 304 of IPC, now in new BNS Section 105, will apply to the following classes of cases. This is a very good paragraph. For number one, when the case falls under one or the other of the clauses of Section 300, that is BNS Section 101, but it is covered by one of the exceptions to that section. 2. When the injury cause is not of the higher degree of likelihood, which is covered by the expression sufficient in the ordinary course of nature to cause death. This is very useful for defense, for the expression sufficient, and normally when the doctor appears in witness box, he says this: sufficient in the ordinary course of nature to cause death. Doctor confirms it, that this was the injury. But if you have a lower degree of likelihood, which is generally spoken of as injury likely to cause death, only the case does not fall under clause 2 of section 300, that is new section, BNS section 101. When the act is done with the knowledge that death is likely to ensue, but without intention to cause death, or an injury likely to cause death. The difference between the two parts of section 304 of the IPC is that is 105 BNS. Under the first part, the crime of murder is first established, and the accused is then given the benefit of one of the exceptions to section 300 of IPC. While in the second part, the crime of murder is never established at all. This is the benefit. Now, para number 6. The word likely means probably, and it is distinguished from more possibly. When chances of happening are even or greater than it is not happening, we may say that thing will probably happen. In reading the conclusion, the court has to place itself in the situation of the accused. Very good. And then judge whether the accused had the knowledge that by the act he was likely to cause death. Para number 12. Page number 2577. In determining the question whether an accused has guilty intention or guilty knowledge, in a case where only a single injury is inflicted, sometimes with a single injury, even man can be murdered. He dies. I'll do it again. In determining the question whether an accused has a guilty intention or guilty knowledge, not simply knowledge, it is called guilty knowledge. In a case where only a single injury is inflicted by him, and that injury is sufficient in the ordinary course of nature to cause death, the effect that the act is done without premeditation in a sudden fight or quarrel, or that the circumstances justify that the injury was accidental or unintentional, or that he only intended a simple injury, will lead to the inference of guilty knowledge, and the offence should be one under section 304 part 2 IPC, BNS section 105 part 2. So, I'll discuss about declaration in some of the video later on. Circumstantial evidence I already discussed. So this is our humble attempt to distinguish between murder and culpable homicide not amounting to murder. Hope you have got some vital information. You have enjoyed this video. Thank you very much for joining with us, and thank you very much for patient hearing. If you are new to our channel, please subscribe it. If you are not new, please like it and share it. See you in the next video. Thank you.